Many times when people come into us needing litigation, it's because they trusted someone's word and relied on a verbal agreement regarding a real estate transaction. In real estate, all transactions have to be in writing. This is called the statute of frauds. This is not about fraud, although handshake deals in real estate often are associated with fraud. But the statute of frauds, in a nutshell, says that any deals concerning real estate have to be in writing to be binding. There are some exceptions, but for the most part, this is the law and the accepted rule in California. I get a lot of cases where family members make deals with each other. I'll buy the house in my name, get the mortgage in my name. You pay the mortgage and I'll hold title for you until your credit is better or until the value goes up so there is more equity for you to refinance. This could be a family member or a friend. In one case, I have a boss that asked his worker to buy a house for him. There are two sides to this, of course. You may buy a property for someone else and they stiff you on the mortgage. You're responsible, your credit is damaged, and you're restricted from buying other properties. In the case of the worker that bought the house for his boss, the boss reported it on a 1099, which caused the worker to get audited and an IRS lien placed on his other property. If you have allowed someone to hold title for you for 20 plus years, they eventually won't want to give the house back to you, especially as the mortgage gets closer to being paid off. Maybe they've even refinanced the mortgage without you knowing it and even took more money out of the property. Soon they'll be referring to it as my house and treating you like a tenant. They will probably attempt to evict you. Sometimes a friend will ask you for a grant deed in exchange for lending you money. Never do this. If you want to borrow against your secured property interest, give your friend a deed of trust and a promissory note for the amount you have borrowed. Make sure the promissory note clearly states how much interest you will pay. Maybe a floating grant deed feels like a good deal because there's no interest and your friend promises he won't record it until you pay back the loan. Then he or she records and promises they'll grant deed back to you as soon as you pay the money. Once you sign and notarize a grant deed, you've given away your title and your property. If your friend records a grant deed, he or she is the owner, and you're a renter, paying off a mortgage on their house. If they're smart, they'll wait 3 years until the statute of limitations for fraud expires, at which point they'll evict you. And again, they will have benefited by tricking you into paying the mortgage during all this time on their house.